Hello, welcome to Legal Action. My name is David Siegel. Today we're going to be talking about divorce and family law with an emphasis on the final day, the day that the divorce decree is entered. Joining me today, as always, is my co-host, Jesse Barantis. Jesse, welcome to the show.
Hey, Dave. Thank you very much.
How you doing, sir?
I'm doing excellent. How about yourself?
I'm doing well. Well, Jesse, you don't have the privilege of being divorced, but you know quite a bit about it by being a practitioner since 1991. You also co-wrote the book, Divorce and Family Law, which I have here with me, which answers a lot of questions that happen during a divorce case. And I want to focus today on the finalization. So we've gone through the whole case. It may be 6 months, it might be a year, it might be 2 years, could be longer.
Sure.
But we finally made it to the final day where you and your client are going to appear before the judge, and you're going to present something to the judge to actually put this case to rest, we hope. So let's focus on that. What are you doing first vis-a-vis your client to get them prepared for this final day?
Well, what sometimes people don't realize, and it depends whether or not it's, like you said, it could be 6 months, 2 months, could be 2 years. The point is, we're not talking about a trial. We're talking about, hey, we've come to a resolution, we've come to an agreement, despite how long it's been. And that may have entailed us going back and forth with proposals several different times, looking at it. I mean, several stuff. I think we're probably going to talk about that maybe on another show. And then you have your final product, and they call it the prove up. You're proving up the allegations of your petition for dissolution itself.
Okay, so how does it work? What is actually presented in front of the court? How is it set up? Who has to be there? And is it recorded?
Well, it is the person that has to be there is the petitioner, the person who's filed initially the petition for dissolution of marriage. Sometimes people file a counter petition, and so if they file that, they generally would have to be there too if they want to kind of have the resolution on that. We had a case one time where the petitioner didn't show up, didn't come. I think that was my client. Everything was agreed, everything was signed. I think it was in Cook County too, and we couldn't really proceed because it was his. So what the judge allowed us to do was to, allow them and waive the fee to do a petition for counter petition for dissolution. We just copied the petition, kind of white it out. I mean, it's just a creative solution to the problem because everything else was done for whatever reason. And so that's why, if you're the petitioner, that you have to be there. And so generally, it's going to be the petitioner, the petitioner's attorney, certainly the respondent's attorney. The respondent doesn't necessarily have to be there unless he or she wants to. A lot of times, folks want to show up because they want the sense of closure. They want to, okay, let's conclude this and let's move it on. In the same sense, some people don't want to be there because, it's emotional, and it is. It's really kind of the death of a relationship.
Definitely. A lot of my clients want to appear at the final court date because they want to walk away with some kind of judgment, decree. They don't know exactly what it's called,
right,
but they want to be able to walk away with something to prove that they are in fact divorced. And in many cases, it's the same document that they've already signed and agreed to. They don't realize that it's only going to receive the judge's signature and maybe a special stamp from the clerk's office, but that in fact is their decree. But let's talk about who else is going to be present in the courtroom.
Well, certainly the judge is going to be there. What a lot of courtrooms have done now is, in a lot of places, there's not necessarily a court reporter. There is an electronic recording that's going on. And so a lot of times you want people to understand that it is being recorded, and they really can't, shake their head or do a shoulder shrug or anything. That's not going to be something that's recorded or go, uh-huh. You have to have very specific answers. Yes, no. It has to be articulated pretty well. There might even be some other people in the gallery, other people waiting to do their prove up, or other people waiting for other things, for the court's business to be there as well.
Right. Now, our show airs all over Chicagoland, so we cover all the counties. But I believe in Cook County, where you actually physically have the court reporter taking down everything that's said, it's a little bit more nerve-wracking. It's much more comforting for the clients to appear in DuPage, Will County, where there is no court reporter. They're just standing in front of the judge with their attorney, and kind of like the pressure is off. You're standing next to the attorney that's represented you the entire case.
Sure.
He or she is asking you yes or no questions for the most part, and it's relatively easy. But in Cook and Lake, where there's that court reporter, it's a little bit nervous. I mean, that's the first time many people have been in front of a court reporter who's taking down every answer, every word that's spoken.
Or even in front of the court themselves. I mean, it's one more person to make them nervous and anxious. People aren't used to doing that kind of a thing, and relatively for us, because we do that all the time, it's really kind of routine as it relates to the prove-up, because everything is in agreement. But you know, they see the judge, they're nervous. They see the other people, and you know, sometimes they do get bent out of shape about those things.
Yeah, well, there's plenty of attorneys that get nervous on that final court date too, and you'll see them looking at notes, reading a cheat sheet, a list of questions to ask. That always baffled me. I mean, if you've handled this case, you're an attorney, you know what you need to prove up, which we're going to get to in just a second.
Sure.
Why do you need the cheat sheet? Why just not follow the judgment, get it on the record, you know, be the hired mouthpiece, the hired gun that you are, and represent your client and put on a show and make sure that everything goes flawlessly?
Well, you know, sometimes I think it could be a question of a couple things. I think sometimes there could be younger attorneys who don't have the confidence and don't feel, although really, and I hate to kind of say that, I don't think that you can necessarily mess up a prove-up that badly. I mean, a lot of times, and we're really fortunate in DuPage and Cook and Kane and all the counties, we really have a lot of judges that will help folks along. Even new attorneys, if they miss something, they'll help them along, and they won't do it in a way that will demean those you know, those attorneys. They'll really build them up, and they're just doing their job and just kind of move it through, and the attorney will know. But sometimes I think people don't want to forget some of the allegations that they have to prove up, you know, for the divorce. If you've done things a bunch of times, I mean, you could, it doesn't matter, the same things apply to every divorce. The only difference is the specifics.
Well, let's talk about it. Every judge, every county, they're proceeding under the state of Illinois laws, the Illinois Marriage and Dissolution of Marriage Act. There's certain formalities, there's certain things that have to be in line, properly signed, and
Sure.
ready to go. Let's talk about what the attorneys need to present to the court in order to proceed on this final divorce court date.
Well, and again, dependent upon the county, I mean, you certainly need your agreement, which is, they call it MSA, Marriage Settlement Agreement, JPA, Joint Parenting Agreement. A lot of times, what I generally do is I combine them so that it's in one unified, cohesive document. I like doing that because people then could look at just the one document, and they don't have to run and look at two different things that people do.
So collectively, your judgment of dissolution is going to contain within it a marital settlement agreement, and or if there's a joint parenting agreement, that as well.
Right.
That is your judgment. It's one document.
That's your judgment, but let's explain. They call it a wraparound judgment, and generally it's 2 pages.
Oh, you happen to have one?
I happen to have a judgment. It's 2 pages, and basically what it says, after the first page, it says they've entered into a written marriage settlement agreement, and it is in words and figures as follows, and then we sandwich the judgment in between, and so that's what it is. That's pretty much ratified or adopted like the court order.
Right.
And
That's
so
the
again,
wraparound judgment, but that's not the only way you have
Right,
can
no,
do
that's
it.
not the only way. You could do a separate judgment, which is you have your document, and then you have your separate one that is just a judgment. Again, for me, I like to make it, and I think it's easier on people where they just have this one document rather than, okay, well, wait a minute, I have to look at this other document or that other document. You know, people don't even look at documents. They don't even ask for somebody to retrieve something, and they can't even find it because we do some post-decree work, which is after the judgment.
Well, this is where attorneys are different because I like to bifurcate. I like to have a judgment, a marital settlement agreement, and a joint parenting agreement. Let them sign off on all of them, staple it all together, incorporate it, and send it up for signature. So there's many different ways to do it.
There are different ways, and again, it's just a matter of preference for me. That's what I like, and that's what I'm used to, and that's what I think that that people want to see. The fact of the matter is that it's the same thing in different judgments. Now there might be a difference. For example, the joint parenting agreement could be entered at a different time. A lot of judges like to get that whole issue of child custody and visitation out of the way, and depending, and there are judges in all the counties that will push those things. Hey, listen, okay, where are we at on this? Where are we on that? Because if we're not in agreement on those things, then one of the first things they're going to do is send it to mandatory mediation to try to stimulate a resolution. And then there are other things. We've talked about those on other shows. But that's what they're really going to try to do to be able to take care of it.
What other ancillary documents other than this judgment are required and that have to be prepared and presented to the court on that final divorce date?
Well, you're also going to need, they call it a certificate of dissolution, and you need that everywhere. In Cook County, I believe, folks file it along with their petition for dissolution of marriage.
That is correct.
In other places, they'll bring it at the prove-up. Is sort of like a, quarter sheet of paper or so, multiple carbonless forms, and it asks very specific information. It asks for the names, addresses of the litigants, where they were born, if they're a citizen, their social security number, and by the way, that that's not something that the public can go in and take care of. That gets redacted. That's just for court.
Right. This is
uses
basically
only.
statistical information that
Sure.
the state of Illinois keeps
Who
track
filed,
of.
how many kids,
divorces,
who's getting
right.
the kids, right, exactly. If somebody's African American or Hispanic, and they try to keep stats on that to see, and they can make determinations of, okay, the divorce rate among these different kinds of groups. So
Right.
that's a document.
And to
that
show you how far things have changed,
Sure.
the original certificate that we still use to this day that the state of Illinois printed up has a spot for social security numbers, which we just put a line through, of course. But back then, they wanted to even know that information, the state did. It was required as part of the form. So it's basically statistical information presented to the court that the state keeps track of how many filings and of what race and nationality.
Right, exactly. And they also look at whether or not this was the first marriage or second or whatever, that kind of thing, too.
Okay. How about a case where there's children and there's going to be a child support order? What's involved in terms of that documentation that needs to be presented to the judge for signature?
Then there's a support order, and they're really pretty standard. The same support order is pretty much the same in Cook and DuPage and Will and Kane. It's the same.
Well, that's a good point.
Kind of
Why don't we have a statewide form then, instead of each county presenting their own form, which does have to encompass all the rules in the Illinois Marriage and Dissolution of Marriage Act?
Well, they all contain the same elements. I'm not sure why we don't have the same thing. I mean, a lot of it's stratified, and it really is the same kind of information. But I suppose they like to show which particular county it came from, and so at the bottom it usually has whoever the clerk of the court is in the particular county on the form.
It would certainly help the state disbursement unit and also employers if there was a uniform order for support in the state of Illinois. That's something I think we should look into, Jesse, as a possible legislative idea for you to propose a uniform order for support.
We can talk about that pretty much. We have it. It's just it's on a different form in each kind of a county is what it is. And that's interesting you mentioned that. It's not just for child support. It's also for maintenance. It could also be for insurance. It could also be for past support or rearage. It could be for daycare. It could be for a bunch of things that they can include on that specific form.
Okay, so we've got our judgment, we've got different documentation, we've got our order for support. We're ready to go. We're waiting in the courtroom. We're waiting for the clerk to call our case. What happens when our case is actually called and that moment of truth has arrived?
Well, they're going to call your case. They're going to talk about the heading, and array the marriage of whoever. They're going to require the parties to identify themselves.
Smith.
Smith.
You're just going to hear Smith.
And you're going to step up, ready for prove up, and they're going to swear the parties in.
Swear them in.
Right.
What's that?
Well,
describe to the audience
basically,
what that is.
Well, do you swear to affirm to tell the truth, the whole truth, and nothing but the truth?
Okay, some people won't swear.
Really?
Some people religiously will not swear. They must affirm.
They must affirm.
Yes,
Swear or
it's been
affirm.
an issue
Okay.
before.
I've never had that issue come up.
It's been an issue with
Because
me.
I just tell them the answer is yes.
Well, there's some people that will not swear. It's against their religion
I'm
to swear.
swearing to tell the truth. But in any event,
They can affirm.
they can affirm. So they're going to be sworn in, and then usually the petitioner's attorney, the person who filed the initial petition for dissolution of marriage, is going to ask specific questions. Now, they have to cover jurisdictional grounds.
Or aren't they going to do a little preamble in front of the judge and let the judge know who they are, who they represent, what the grounds are, to give the judge a little bit of a background so the judge is not shocked by what's coming forward?
Well, I don't think the judges are ever shocked, but they're gonna hand up a copy of the judgment. The way I usually do it is I get all the originals together, hand all the documents we were talking about to the judge, the judgment dissolution, the marriage settlement agreement, whether or not that's sandwiched together or not, the support order, and the other documents, the certificate of dissolution, the document to have a default matter heard. It just depends on where you're at.
Right.
There's certificate of counsel in other places in Cook County, and so we're going to hand all of those things up.
But you approach with pride. You have your shoulders back,
Sure.
your chest out, you're walking up there with confidence, you're greeting the judge, and Your client is there on your side. Unlike some attorneys that may not have that kind of bravado, you're up there. It's your final day, and you're.
This is it. Hey, listen. This is the Super Bowl for those people. Okay, you know what? This is the big game. We're done. It's taken care of. They're going to move on with the rest of their life. They're going to be able to have some kind of closure. It might not be a good thing. Not everybody wants a divorce in those cases, but hey, guess what? It's a starting point for them to get on with the rest of their life, and it's very, very important. So it is a big deal. It is something you want to take care of, and you prepare them ahead of time and explain to those. But what's going to happen is, you're going to give a little background in terms of, okay, they're going to identify the parties, especially for the record, because the court reporter is going to need that if they ever need the transcript. And in some places, you'll need to order the transcript. I know in Cook County, you might get away with having it waived, and
Most likely you're buying it.
right, you're buying it, and well, that
good for
brings
the
up a whole
economy.
new, it's good for the economy. That's a great way to say it. So that's what you're going to do, and then the very first thing we do is when, after all those things are done, then the judge will say, counsel, okay, and then you call your witness, which is generally your client, and you just ask them to say their name and to spell it for the record. Again, if it's Smith, I don't know how you can mess up Smith, but believe me,
No E.
I guess, right? So you want that, that down for that, and then you're going to ask them just kind of basic background questions. Okay, Mr. Smith, you're the petitioner in this petition for dissolution. Is that right? Yes. Okay, and you're going to ask.
Okay. You're going to cover some jurisdictional
requirements.
Which are what?
The jurisdictional requirement that you've lived in the state of Illinois for 90 days preceding the filing of the petition for dissolution of marriage, and also.
Or your spouse must have lived in the state
Or your
of Illinois.
spouse, right. And sometimes you might get a particular judge. I mean, depending upon how long a case is going on, it could be that neither one of you live at this moment in time in this jurisdiction. Now, generally, I think it's okay, but there are a few judges that is probably going to give you a hard time for that. I mean, as a judge, and I'm not, but hey, we're ready. I do have jurisdiction.
Not yet.
Not yet. Let's get it done and let's finish it up. Let's not punish these people and make them transfer it someplace other. But there are some judges that may give you a hard time. So you're going to bridge that procedural gap. And this is what it's called proving up. You're proving up the allegations of the divorce, and you do that with the testimony of the parties. Okay, so you're going to ask, whether or not they've been domiciled in the state of Illinois for that period of time. You're going to inquire into, okay, you were married on May 26th of 2000 in Cook County.
So dates,
Illinois.
names, ages, the facts.
Right, exactly. Any children you identify as a result of the marriage. There were 1 child, 2 children, 4 children born of the marriage. You might even go into their ages, and that no children were adopted, and the wife is not now pregnant, not now in expectancy. Now, I mean, that sounds for the average person, what are you talking about? We're getting divorced. Why would we be pregnant? Hey, incubation period could, and then that brings up.
Even an elderly woman, you still have to ask that question
you have to ask
that you
everybody.
can get the statutory requirement done.
That's right. And adoption, too. I mean, I've done several cases where, hey, they didn't have any natural children. I don't want to say that because, to me, an adopted child, I mean, that's your child for all intents and purposes. So, I don't want to give that any kind of credence where it's not natural, but you know where I'm coming from.
Same issues apply.
Same issues apply because if you've adopted somebody, right, and, that's just as if you had conceived a child together, and they're going to have the same rights and responsibilities and obligations and duties that you would have with a child that was born there.
Okay, let's talk about the next statutory requirement, which is the grounds for dissolution,
right,
which sometimes could be contentious, depending on what they are. Most people are familiar with irreconcilable differences. Right. That's where it's nobody's fault. We just couldn't work it out. We've been not functioning properly for at least 6 months.
And that's the other thing that has to go along with that. If it's a situation in the 6-month period, actually it's a 2-year period of time that you have to living separate and apart, but 6 of that, you can waive all of that except for 6 months.
Okay.
But it's been construed to mean not necessarily physically living separate and apart. So a lot of times people will live together in the same house as kind of roommates do. Sometimes somebody will live in a different bedroom, really, and they'll come and go and do their own thing. Sometimes they'll even stay in the same bed, but they're just like really roommates, and they haven't had marital relations in a long time, and that's also been construed to make that period of time. In a situation where you're doing a prove-up and it's by agreement, nobody's going to say for the other grounds that, oh, I've committed adultery, or I've been mentally and physically cruel, although those are other grounds that don't require a waiting period.
Right. Now, some parties are adamant that they want the other spouse guilty of something, so they'll insist on mental cruelty or physical cruelty or adultery, when in fact irreconcilable differences have also occurred and led to the breakdown of the marriage, but they want that on the record. And in my experience, Jesse, the grounds really don't matter. It doesn't affect division of property or allocation of debt. So it's just one of those issues where if you can reach an agreement on some of the softer grounds, you're probably better off, but you can't always do it.
Right, and I think you got to try really hard, because again, just like some people want to, I want that admission. Hey, you know what? I'm not going to admit, and it's pretty horrible thing here to say, okay, we're in agreement on everything, Judge, except we can't agree on grounds. I'm certainly haven't been. I'm not going to admit that I've committed adultery or I've been, mentally or physically cruel. It's not going to happen. Not today, not tomorrow, not ever.
Right, and that's where the 6-month statutory period that could be reduced down to comes into play.
Right, and so sometimes, hey, if you have really that adamant, and it really comes up to the lawyers and their powers of persuasion and counsel, really, to help their clients get through that kind of lump, because a delay in that could end up costing them, another $1,500-$2,500. Okay. Just anything for that. So, those are the things you're going to cover. You're going to cover the grounds. You're going to cover basic issues in terms of, who's going to have custody of the kids, whether or not it's going to be sole custody, joint custody, and you can refer to the visitation that's outlined in the agreement itself. Okay. There are specific things you have to hit, though, and you know what those are as well.
Yes. Now, all the while that you're reciting these facts and going through these different grounds and allegations, the judge is also looking at a copy of the judgment as you're doing it, correct?
Correct.
Okay. Now, does the judge ever have additional questions of you or of your client?
Sometimes he does, and this gets into what you were talking about earlier. Sometimes, you mentioned that somebody has a little cheat sheet or whatever, and I think you could just look at your judgment and go down it and then pretty much kind of
the facts are there on paper.
The facts are there. But, if you miss something, and, it happens. Sometimes there might be distraction or whatever. You might miss something, and the judge, will ask, or maybe the judge didn't hear you say that, and you might have already addressed that issue.
Right.
Then, he's going to ask about that.
Judge will say, well, did you cover grounds?
Right, exactly.
Yeah, that was one of the first things I did, but, each judgment's different, so
Right.
the judge might have been leafing through and not seeing grounds. So we oblige.
Right,
and we cover it again.
Absolutely.
Because what's the harm?
There's no harm whatsoever.
So you run through it again. Or have you covered maintenance counsel? Yes, but I'd be happy to do it again, Your Honor, for your knowledge.
And those are the couple things, too, that you specifically do talk about, and that is about maintenance. Maintenance, formerly called alimony.
Now, why is that such a big one? All judges do want that covered in detail, but why is that so important? There's a reason.
Because if it's waived, that's it. Once you waive maintenance, and they want to put that on the record so that the person is basically making an informed consent, even though they've signed off on the paperwork, they want that testimony, that allegation that, hey, listen, you do understand that you're waiving maintenance. Yes, you're able to support yourself. Right, you don't need assistance from your spouse to be able to support yourself. No, you do understand that if you waive maintenance, you can't come back to this courtroom or any other courtroom at any time in the future and ask for it. Basically, you're done, you're out, it's finished. And so they just want to make sure that, with such finality, that you have a grasp of that, and you have an understanding.
When you say waive, you're effectively saying you're waiving your rights.
Right.
Goodbye.
Exactly right.
Okay. So waive something is to...
Right. Anytime you waive your rights, that's true. And then one of the other things they talk about like that would be the pension plans, those type of things. And sometimes people do waive them, it's a consideration, or sometimes they get split. The other person gets the marital portion of that, and it has to be affected by a vehicle called a quadro qualified domestic relations order, other dependent upon where the pension comes from. But you want to talk about that to see what the deal is on that, and generally, in the nutshell, that's really it. Some other judges, however, want you to get more specific. My opinion is that, hey, everything is contained in the agreement, but again, it comes down to what you're talking about. Okay, Your Honor, if that's what you require, that's what you want to hear about, we'll talk about it, no problem.
There is a judge in Cook County that takes all the judgments into chambers, reads them. It might take her an hour and a half to come onto the bench, because if she's signing her name to it, she's going to read every word of that judgment, whether it be boilerplate or something specific.
I don't
There's
think
one
that's a bad
judge that does-
idea.
It's not a bad idea, and oftentimes she'll want the judgment in advance.
And that's an
so
even
that she
better
can do
idea. So
that.
she's ready. I really, I really can honestly tell you that is. I don't have. Again, it's a. I don't want to even call it a quirk. It's a matter of your name being to. You want to make sure that there's nobody's trying to sneak something in there. I'd be more concerned if you were in a pro se situation where there was an attorney on one side, and pro se means you represent yourself, and you don't have one, and that I could see maybe the judge wanting to look at a little bit more specific, because I've seen so many of those where, boy, somebody's got a pounding that you won't believe that really should never have happened.
All right, let's talk about something that we neglected up to this point, and that's the identification of the signatures throughout the judgment and/or agreements.
Sure.
There's emphasis on that. Can you talk about that?
Sure, as an exhibit, when you're talking about the agreement, you'll have the agreement together, and you'll ask, let's say, I represent the wife. I'll say, okay, Mrs. Smith, that's what we're talking about, right?
Yes.
Mrs. Smith, have you ever seen your husband's signature before? Yes, I have. And you're able to recognize it? Yes, I am. And so I'll show her the last page of the judgment. Could you look at that? I'm going to give you what we're going to mark as Petitioner's Exhibit A for identification. Can you tell me what that is? Yes, that's the marriage settlement agreement. Okay, on the last page, on the signature pine, is that your husband's signature? Yes. Is that your signature? Yes. And so you want to identify. Sometimes I like to do, I like to notarize them. I mean, we still effectively go ahead and do the same thing I just mentioned, but they're notarized, because what a notary does is it just says that the name that's on there is the person who's signed that document, and that's what you're doing through the testimony.
Right. What about attorney's fees? A lot of attorneys at the end of the prove-up will ask, not so much fees, but were
Sure.
they pleased with the representation? They want their clients to state on the record that they're happy with the representation.
Right, are
Is
you
this just
satisfied
a-
with your representation?
Is this
Sure.
a cover the tail kind of activity on the part of the attorney, or what's the reason for this?
Well, I mean, realistically, that's what it is. You want to have that on the record that you're satisfied. I have to tell you that if we were up there and somebody said, "No, I'm not satisfied," then you know what? I've never had it happen, but I'm probably going to say, "Okay, Your Honor, I move to withdraw. We have to continue it. I'm not going to." If they're not satisfied, then we can't continue, because then that just opens up another kind of can of worms.
Yeah,
But generally, there's not an issue.
It's an interesting line of questioning, but I don't think that simple answer at the prove-up is going to undo any kind of malpractice or malfeasance that might have happened throughout the case. So it's almost like it doesn't need to be done.
Right.
So
I could be happy with your work, even though you might have messed up. I mean, like you're right. It's not going to make that big difference.
Right.
But yeah, you usually settle up. I mean, we generally, if the attorney's fees aren't paid in full, we'll do a consent judgment, which basically the client is informed of his or her rights, that they have the right to be represented by an attorney other than me at the hearing on a petition for attorney's fees, that they have that right to respond to it in writing and to do it at a different time, and that they are, again, it's another waiver of rights, and it's supported by their affidavit, by my affidavit, by a petition, and everything else.
Okay.
And so usually that's taken care of.
okay, let's say the judge is happy with the agreement. There's nothing unconscionable about it.
And
The judge-
unconscionable, tell the folks at home what unconscionable means real quick.
Well, unconscionable is basically the judge feels that there's something in this agreement that's unfair. Maybe one party is getting 95% of the property and the other party is getting 5%. So it can't be unconscionable. It's got to be fair and reasonable. But if they find it to be fair and reasonable, they'll do what? They'll sign it and then we're done?
They'll enter the judgment. The parties will be divorced. However, I know in Cook County there's an issue. You have to order the transcript because it's not prepared. I mean, it is prepared in shorthand, but then they have to kind of translate it and make it acceptable, and you have to pay for it.
Right. But if you're represented by counsel, you're going to get a judgment that day. You're going to be able to walk out with a copy of your judgment.
Generally, that's right.
Well, Jesse, thanks for joining me again once again.
Dave, thank you
We've been
very much.
talking about divorce finalization, that final prove-up date where everything gets wrapped up. You walk away unmarried, and that's what the goal was all along. We'll see you next time on Legal Action. Take care.